Hi everyone, my name is Vlad Genshu and I'm a trial lawyer in Los Angeles County Superior Court. I practice personal injury litigation and personal injury jury trials, mostly in Los Angeles County, but I've also tried jury trials in Orange County and I litigate throughout the state of California, its state superior courts. I want to talk to you today about something that rarely happens, but there is an opportunity for it, and that is settling a personal injury lawsuit during a jury trial. For the vast majority of the time, your personal injury lawsuit is going to settle well before trial. I'd say 97, 98% of the time, a personal injury lawsuit is going to settle well before it gets to jury trial. There's a lot of reasons for that. One of the reasons is cases tend to get very expensive at the end. You need to designate experts, demand experts, usually 70 days before trial. You designate 50 days before trial. Sometimes you have to have a retainer for those experts. Those expert depositions cost money. They cost money to take, cost money for the expert's time. The attorney's time needs to be put in. The cases really balloon at the end. You got to put together trial documents, trial binders, all that kind of stuff. We kind of talked about that in the last videos, but I want to talk about the rare cases that not just go to trial, but that settle during trial. You've sometimes seen that during movies or TV shows. I want to make this clear. This isn't meant to dramatize anything, and it's not meant as specific legal advice, but I have settled two jury trials during the actual jury trial. So I've settled two personal injury cases during the jury trial, and I've had an offer to settle another one during the jury trial. There's a lot of reasons for this. The reason is, if you think about it, a personal injury case is ultimately risk management on both sides. You have risk management on the plaintiff side, and you have risk management on the defense side. I had a mediator tell me this, that insurance companies and their adjusters usually get the value range of trials or settlements in terms of what they're going to end up in terms of a jury verdict. They get them right about 80% of the time. But that 20%, when the insurance company gets it wrong, they don't get it wrong by a little bit. They usually get it wrong by a 4-to-1 or a 5-to-1 ratio, which sounds about right, because I've tried 11 civil jury trials to verdict, 12 in total. We'll talk about that one that settled during trial. And I've just tried another one that settled during trial, but it didn't get past jury selection, settled during jury selection. So I wouldn't really consider that a trial, because no witness was brought to the stand yet, or no opening statement started. So when you look at the issue of risk management for a plaintiff, it's actually pretty simple. If you get a verdict below what the defense offered you, so if the defense does what's known as an offer to compromise by California Code of Civil Procedure 998, they can do that 10 days before trial. If they do it, 2 years before trial, and they offer you $100,000, and you only get $100,000, you don't beat it, if you will, by a cent or more. You're on the hook from the time they made that offer for their costs, expert costs, everything from copy services to depositions to everything. So basically, your verdict, let's just call it $100,000 or $99,000, gets taxed, gets subtracted whatever the defense costs are. 998s are very strictly construed, but it's a big risk. And then you got to deal with, how much is the client going to actually get in his or her pocket? What are the medical bills going to be? Are you going to be able to reduce them? What is the attorney going to get? What are the attorney's costs? It's pretty simple on the plaintiff side in terms of actually putting together what the risk structure is. On the insurance defense side, for the insurance defense law firm and the carrier, the insurance carrier, it's a little bit more complicated, because they usually don't have all the information, because they can't, right? The plaintiff's case is the plaintiff, the medical bills, the human story. A lot of that the defense does not have access to, because they can't contact the plaintiff, because the plaintiff is represented. The only time that they've fully had contact with the plaintiff is maybe for 2 or 3 hours when they depose the plaintiff. And now with the Zoom, it's far more disadvantageous for insurance defense firms, because you're looking at a Zoom deposition, which is, you don't really get a full feel of the plaintiff. if you're watching this video of me, it would be way easier for you, to assess me if you're right in front of me. Same story with a Zoom deposition. The insurance defense lawyer doesn't really get the full picture. Other than that, unless they, do a little bit of investigative work on the side, be it, running Facebook or Instagram or some kind of, they don't really get a full picture of the plaintiff. That's something that the plaintiff's attorney does if they do, serious preparation before the deposition, and obviously serious preparation before trial. So they're not really fully able to put a dollar amount on the human aspect of the trial, the pain and suffering, the general damages. So that could really go haywire for the insurance company. And then you have the issue of bad faith, which is if they're dealing with a very small policy, let's just call it a 30 policy, 15 individual, 30 group, and the plaintiff's medical bills are $30,000, but the insurance company doesn't believe that anybody will believe the plaintiff, and that the plaintiff's case is really tough. If the plaintiff's attorney and the plaintiff, do a great job at trial, and the jury finds the plaintiff to be credible, that's what a trial is all about. It could blow through that policy limit of $15,000 and end up with $100,000 verdict. At that point, the insurance company has committed bad faith. So you have that issue right there. So that's really what both sides are looking at when they're trying a case. So why would you ever actually settle a case during jury selection or during the trial? Because you are confident in your case, but you want to see the other person's case. So for the defense, a defense attorney often will look at a case in terms of strictly the numbers, right? They'll look at the property damage, how big is it, how much, the estimate, which usually never comes in, it's hearsay. They'll look at the medical bills. They'll look at the treatment, if the quote unquote treatment makes sense to them. They look at what I call the hard aspects of the case. But again, they don't really know how the plaintiff will come across other than from a deposition. So the plaintiff's attorney, on the other hand, sometimes needs somewhat of a reality check about how will a jury respond to their case, his or her case, the client's case. So you often see that during the trial, and you often see that during jury selection. There's a lot of good signs. For example, if you're doing a jury selection and you're in a low impact case, then you need to often think about, how is the jury responding to themes that you're introducing in jury selection? There are several themes that a good plaintiff's attorney will explore in jury selection. The first one will be, if the treatment begins with a chiropractor, do juries hold chiropractors to a low opinion level? Do they hold them to a higher standard in the sense that they don't believe what a chiropractor is going to say? If there is a low impact, you need to look into the idea of anybody on the jury that is an engineer or somebody who's trained in physics. Are they going to bring that in to, that past knowledge into jury deliberation? Are they going to try to sway people based upon their knowledge on that? If you have people that have experience with low impacts, and have they or have they not been injured? And all these questions need to be asked, but they're tough questions. People often, and I had this problem as well, people have the misconception about jury selection that as an attorney, you can say something which will offend the jury. You probably can, but I don't really think that should be the focus. The focus should be, how can you get the jurors that are against you to say everything negative about your case? They're not going to change anybody else's mind. It's kind of a misnomer to think that somebody's not met is going to change their minds about personal injury or lawyers or lawsuits. They either have their views set in by years and years of experience. So when you look at that jury pool, the 40 people that come in, 12 that'll sit on the actual jury panel, maybe another 2 or 3 that sit as alternates, depending how long the trial is expected to be. You need to think, if I am looking to try this case to verdict, what do I need to find out about this jury that will make my case be horrible? And then try to figure out to deselect them. That's one of the reasons why trying a case and trying to settle it during a jury trial makes sense. Because if you think, as the plaintiff's lawyer, that your case is stronger than it really is, and you're going to try the case, then you get your gut check, if you will, almost in a focus group like environment from jury selection. They will tell you what they think about chiropractors. They will tell you what they think about, you know, epidural injections. They will tell you what they think about low impact. They will tell you all these things, and that's something you take into account. And when you take those things into account during jury selection, it will put you in a certain way to evaluate your case in front of the jury, because you're staying with that jury, right? If you end up getting 12 of those people and you've burned through all your peremptories, 6 of them, and you know you've only gotten 3 or 4 off for cause, or 2 or 3 more likely if you're lucky, and you know, look, this jury has said X, Y, and Z about this case, you know what panel you're going to get. So let's talk about the cases that I settled. One was I walked in on alternate jury selection. Gabriel Avina, a very skilled and experienced trial lawyer, allowed me to co-first chair the trial. I did about 25 to 30% of the case. It was a quadriplegic and traumatic brain injury case against the city of Los Angeles. And we had a very tough liability case. We settled it right before my rebuttal argument for $3 million. That's on the record. I can tell you about that settlement, so it's not like it's a confidential settlement. It was put on the record. And we settled it because we had a tough issue on liability. First thing that I do whenever I get out of a jury trial is I go and I talk to the jury. I ask them, generally speaking, if it's a big trial, the jury will stay and talk to you. So I talked to them. I said, how would you have voted on liability? Because there is an issue, very tough issue on liability there. I don't really want to get into the specifics, but the settlement was only for $3 million because of the liability issue, and only one would have voted in our favor on the issue of whether the defendant was negligent in causing this injury. Otherwise, we would have gotten washed and would have gotten nothing. So it was a really, really good idea to settle for that $3 million. Obviously, we did a lot of risk management there. We thought about what was going to go on. We clearly conveyed that offer to the client. The client's the person that said yes to the $3 million. The other case was I tried a case actually last week in October of 2023 in Van Nuys, and in that case we had clear liability in our favor, but there was an issue with substantial factor, meaning could the impact have actually caused the plaintiff's injuries. And the issue with that, we settled that during jury selection, and we took the policy, which is a minimum policy, 1530. But the reason we had to settle is just what the things the juries were saying was really, really rough against us. They basically doubted that they doubted, given the fact that the cars were so large, that whether there could have been any injury. It was a low impact case. But a good jury selection, and we only did jury selection for 30 minutes in that case, that is what you'll get. You'll get the bad stuff out, and it'll really tell you, look, I mean, the issue in that case was the defense costs were going to be about $70,000, and the client is on the hook for those costs. So we didn't feel it was right to basically to put the client in that position. I talked to the client, obviously, during lunch break, during the break before we were going to go back and finish jury selection. I said, listen, I think that there's a very good chance that we will not get over the substantial factor, and I think that we need to consider settling. So, and we did. So you always have to put into account what are your client's best interests, first, second, and third, all the way, and never last. It's always the client. If there's an opportunity to settle the case, and during a jury trial, which rarely happens, and you think that is the client's best outcome, you just got to do it, then you need to consider settling. And there was another case where we had a jury offer, an offer from the insurance company during jury selection. That was on the third trial. So when you look at it, most cases, they don't go to trial. And I would say that most cases that do go to trial, they do not settle during trial. The reason they went to trial is the parties, plaintiffs and defense, are very much on, if you will, on different tracks. They different valuation of the case. They think the case is worth very, very different amounts of money. But you always have to put your client's best interest first. If there's an opportunity to settle the case and you believe that you're going to frankly lose, or you don't think the outcome is going to be what you think it's going to be, and you've learned enough from the jury or during the trial, then you need to consider settling. And you also need to consider when you're going to settle, because obviously the more bad information that